I first want to say hello to everyone. My name is Maurie Louis, and I am, as of this morning, the new president of the League of Women Voters of Kitsap. I want to welcome all of you to this year's annual keynote address. A little housekeeping first, and we will be inviting everybody to do chat at the end of her talk. So at the bottom of your screen, you can chat in some questions that you might have. Of course, these questions can't be about any current cases or issues that are most likely to be brought up in the near future. But you can ask her all sorts of questions about how she got to where she is now, and it's very interesting, very interesting. I also wanted to let everybody know that the live transcript has been enabled. So in your more, where there's 3 dots down at the bottom, I believe you'll be able to go there and set up live transcript if it's easier for you to read than to hear. So also, before we begin, I'd like to share a little bit about the League. The League of Women Voters was founded in 1920 during the days of women's suffrage movement. We're a nonpartisan organization, meaning we do not ever support or oppose a candidate or a political party, but we do work hard to influence public policy through community education and advocacy. We are a nonprofit membership organization inviting all genders, not just women, to join and help us organize events such as this one. You can see more of what we are doing at, and of course, join at our website at lwv-kitsap.org. So go there, and we'd love to hear from you. As I may have mentioned, we are very pleased to have Washington State Supreme Court Justice Raquel Montoya-Lewis. She accepted our invitation to give our 2021 keynote address. And as I said, after her presentation, you can use chat to ask questions. Justice Montoya-Lewis was appointed to the Washington State Supreme Court by Governor Jay Inslee in December of 2019. And she took her oath of office on January 6th of 2020. She's an enrolled member of the Pueblo of Isleta and a descendant of the Pueblo of Laguna, 2 federally recognized tribes in New Mexico. She's the first enrolled member of any tribe to sit on a state Supreme Court anywhere in the United States. And she is the second Native American to sit on a state Supreme Court. She is also of Jewish descent. Prior to becoming an associate justice, she served as a Superior Court judge for Whatcom County for 5 years, where she heard criminal and civil trials and presided over the Whatcom County Therapeutic Drug Court. In the 15 years prior to her work on the Superior Court, she served as a tribal court judge for multiple tribes in the Pacific Northwest and the Southwest. She served as chief judge of the Upper Skagit Indian Tribe and Noosak Indian Tribe and the Lumni Nation. In addition to her work as a trial court judge, she was a tenured associate professor at Western Washington University's Fairhaven College, where she taught law-related courses and courses on cultural identity development. She's continued to use her teaching skills as a jurist, teaching a wide variety of audiences, including judges, social workers, lawyers, and advocates on implicit bias, the Indian Child Welfare Act, and best practices in child welfare and domestic violence cases. Justice Montoya-Lewis graduated with her BA degree from the University of New Mexico in 1992 and completed her law degree and Master of Social Work degree at the University of Washington in 1995 and 96, respectively. Justice Montoya-Lewis is going to share with us her journey to the Supreme Court and what state courts can learn from tribal courts. Please help me welcome Washington State Supreme Court Justice Raquel Montoya-Lewis. Thank you.
Thank you. Thank you, Maurie. I appreciate the invitation to speak to the league today. And sorry we can't all be in person for this, but this is the next best choice. And I'm really honored to be able to have some time with you today. And I'm happy to share some of my journey to getting to where I am today. And I'm looking forward to sharing with you some of what I learned in my work in tribal courts and how I think that work translates to the work that I'm doing now and the work that I hope we can do as a legal system, and how some of those things may be applicable to that work. I do invite questions, as Maurie pointed out, and so I'm happy to have you put those in the chat. You can do that at any point. There are people monitoring those questions, and so don't feel like you need to hold them to the end. I won't answer them while I'm talking, but when I get to the end, we'll start with those questions. So I guess I'll start by saying, I never set out to be sitting on any Supreme Court. That was up until really I was appointed, that seemed to be a wild and crazy idea. Before I went to law school, I'd never met a lawyer. I'd never met a judge. I went to law school because I was interested in being a professor, and as you've heard, I did do that, and I was able to use my education and training as a lawyer and as a judge in my years of teaching. But what I was really interested in understanding when I went to law school was how the institution of law impacted people. I began that sort of series of questions really by just observing that it wasn't just a social contract that made our society function. It was also people obeying laws. And I began to think about that pretty early on in my undergraduate education, when I was literally watching traffic and thinking about, why do people stop at stoplights and why do some people run those stop signs or stoplights? And I really started recognizing from there the enormous impacts that our legal system has on everyone, whether we're conscious and thinking of that or not. We act in ways to prevent ourselves from getting in trouble. We act in ways that are sort of assumed to be appropriate ways to behave because they're codified in the law. And it really has tremendous impacts on even our interactions, what we do or don't do in a classroom, for example. So I went to law school to think about those questions, and I went to the University of Washington and found that at that time, the law school was really very focused on that question in a very theoretical way. And I thought that was what I was interested in. But once I got started there and in my first couple of years of law school, I realized what the school was talking about wasn't what I was interested in talking about. They were talking really about the theory of law, but they weren't very interested in talking about the application of that law to people. And so I ended up at the University of Washington's Graduate School of Social Work. And I say ended up because, once again, I didn't plan to get a master's in social work. I literally walked into the building and started talking to the people there to find out what they were doing. And they were talking about people. So the combination of those two degree programs, the law and the social work programs, really gave me what I was seeking in terms of trying to put together an understanding of how the system of laws that we all seem to abide by or understand exist affect individual families. didn't really think much about why that was an interesting question to me until much later when I started teaching. And when I started teaching, I first taught at a law school in New Mexico, and at the time I was living on my reservation. I had gone back to New Mexico. My husband and I went back to New Mexico after I finished law school. And I worked for a Supreme Court justice in New Mexico for a couple of years. I worked in private practice, and then I was able to start teaching at the University of New Mexico Law School. And at the same time, I started working as a tribal court judge, and I was working for my own tribe. My tribe is very different from the tribes that are in the Western Washington area. My tribe was a tribe that had never been removed by the federal government from its homelands. So my community has been there for thousands of years. There are buildings in my village that have been inhabited for thousands of years. Our language is intact. Our culture is largely intact, and our spiritual and religious practices, and that includes legal practices, are very much intact. And so the legal system that I first started working in the tribal court system was a legal system that looked very, very different from anything I had been taught in law school or experienced while I was in private practice or working for the justice I worked for on the New Mexico Supreme Court. Our court system operated in both English and the Tiwa language. I'm not a fluent Tiwa speaker, so I often had a translator so that the proceedings were occurring in the Tiwa language and it was being interpreted and translated for me, even though everyone else in the courtroom understood and was speaking fluent Tiwa. And then the law itself was not law that was accessible to outsiders. It wasn't something that was written down. Most of the law was communicated through what people refer to as an oral tradition. That doesn't mean that it was not law. It was very clear what the law was and wasn't in many respects. But the way it worked was if you walked into that courtroom, you would recognize that there was a judge because I did wear a robe in that courthouse. I have not worn robes in every tribal courtroom that I've been in, but in that one I did. But the proceedings looked completely different and the goals were completely different in that tribal court. So it was really the first opportunity I had to think about why my own community did things in a way that was as different as it was from the legal systems that were 15 minutes to the north and south of our reservation. And it began to make me think about that original question about why I went to law school. What are these institutions of law doing? How are they functioning? And why is the one that I have been drawn to work in the tribal court system so different? And what makes it different? And I began to think at that early stage in my career about the way that I was raised and the values that I was raised with, and how that affected the way that I think and the way that I view the law and the concept of community. And I realized that who I am, where I'm from, really impacted and changed the way I thought about the legal system and how I had approached my legal education. So over the course of my 15 years as a tribal court judge, and in that time also working as a professor, I moved from teaching in a law school to teaching at Western Washington University at Fairhaven College. And at Fairhaven College, I had the opportunity to teach law-related classes to undergraduate students who were thinking about going to law school. But I also had the tremendous flexibility and gift as a professor that very few professors get, and that was to develop classes in anything I was interested in. And I have become very interested in cultural identity and how who we are and who we understand ourselves to be impacts the way that we think. And as a result of that interest, I was able to develop a couple of courses looking at how our cultural identity develops over the course of our lifetime. And I taught that class for many, many years. That class really gave me this framework to look at what I was doing in tribal courtrooms and look at how those systems reflected those communities. It gave me an opportunity to then apply that to our state court systems and say that, and think about how our state court legal systems and our federal systems reflect an identity, reflect a series of values and a series of beliefs. And that was really the framework for both my work as a professor and the work from that point forward I began doing as a tribal judge. So as a tribal court judge, I worked for tribes like mine that were very private. Courtrooms were not open to the public. Proceedings often took place or occurred in a language other than English, and I had an approach to legal issues that was utterly distinct from anything I had learned in law school. And I also worked for tribes, and the Lummi Nation is one of them, that had a completely different tribal court system that would look very familiar to most lawyers and anyone who'd watched a lawyer's TV show. That walking into that courtroom at the Lummi Nation would look and feel very familiar to really anyone. And I practiced as a tribal court judge. I was the chief judge for the Lummi Nation and oversaw what is a very complex and active tribal court system. And while I was there, every few months, the ordinances or the written law of the tribe would get added to and more developed. And by the time I left the Lummi Nation, we had a huge body of written law, which was, as I said, completely distinct from the law at the time that I worked at the Pueblo of Isleta for my own tribal court. The Lummi Nation also had an appellate court system. So as the trial court judge, and we had a couple of other trial court judges as well. So there were about 3 of us, depending on what year you were talking about. There are 2 or 3 full-time tribal court judges. Our decisions could be appealed to an appellate court that looked very much like the Court of Appeals does on the state court side of things. Those appellate bodies for the Lummi Nation would make decisions and do those decisions in writing. Those decisions would be published. They are accessible online, and it is very much a legal system that looks in terms of the structure like a state court system. And then I worked for many other tribes that had systems that were sort of what I'd say in between those two. One that's very private, courtrooms are closed, proceedings occurring in tribal language and applying tribal customary law, to a system that is quite reflective of the structure of a state court system and has written law that you can go and look up, has lawyers practicing in the court, has a process by which you need to be admitted to the bar before you can practice in that tribal court. And then I worked with tribes that had courts that are sort of in between that. I was the chief judge for the Upper Skagit Indian tribe. In that courtroom, it was like a conference room. I was not elevated above anybody else. I did not wear a robe. We sat around a table and discussed the things that brought people in front of the tribal court. And we met once a month, sometimes twice a month. So very much a part-time tribal court there. And then I worked for the Nuksak Indian tribe. And I was given the tremendous honor of having the ability to work with that community to develop their tribal court system really from the ground up. There was a very part-time tribal court system. They wanted to make it a full-time tribal court system. primarily in order to work with families and children who were involved in the child welfare system. And so I was able to come in as a chief judge there and work with the community to figure out what they wanted from a tribal court, how they wanted that court to approach problems. We went from very basic kinds of questions about what should the courtroom look like? Should the judge wear a robe or not wear a robe? Would our courtroom proceedings be open or closed? Really an opportunity that is kind of a once in a lifetime opportunity to develop a system from a very minimal legal system to a very robust, active system doing both civil and criminal cases. So as I said, I did that work in many different tribal communities for many, many years. And there was an opportunity that arose to come and consider applying for a superior court position that had been opened up in Whatcom County. And I had several lawyers ask me to consider applying for the appointment to that position. At the time, it was Governor Inslee who was going to be making that appointment. There were, as far as I could tell at the time, no examples of people who had been tribal court judges who then made the switch from the tribal court system into the state court system. So it seemed like a tremendous leap to me to make that move. But I talked to a lot of people about whether or not I should consider applying, what that would look like for me, what that might look like if I had to run a campaign, and what the work would be and how it would be different from the work that I was doing as a tribal court judge. And I eventually decided to apply. It was a very long and complex process. It took about 6 months, and was appointed and by Governor Inslee and sworn in January of 2015. And I spent 5 years on the Superior Court bench. It was immediately apparent to me that the work I was going to be doing as a state court judge was going to be very, very different from the work that I had been doing as a tribal court judge. The basic job description is the same. You're a judge, you're there to make decisions. You're there to solve problems, to help the community solve problems. But as a tribal court judge, no matter what tribe I was in, the expectation was that I would understand as much as I could about the communities that I was serving and about the families and individuals who came in front of me. At every tribe that I worked for, the expectation was that I would understand not just the person or family that was in front of me, but what their role was in the community, how they served their community, what would happen if they left the community, for example, to go serve a jail sentence for some period of time, what would happen when they came back. There was always an understanding at every tribal court system that I worked for that even if you were taking people out of the community for one reason or another, and by that I mean sending them away to go serve a jail sentence, or removing children from their parents' care in child welfare cases and having those Native children in the care of non-Native families. There was always an understanding in the tribal courts that those people would come back and that they would be a part of that community again. And so there was always, it was always part of the expectation of that communities that I was working for, that I would be conscious of what does it mean to take someone out of the community, and what will it mean to welcome them back whenever that happens, whether that's in 20 days or 20 months or 20 years. There was always an understanding that when people left, they would come back. They never stopped being a part of the community. In the state court system, I had kind of the inverse set of expectations. And what I mean by that is that there really is an expectation in our American court systems that judges are quote unquote neutral and objective. And by that, we mean that the values our system is supposed to reflect is that judges they're often referred to colloquially as kind of umpires. They call balls and strikes. And they're not supposed to bring who they are to those decisions. We're sort of taught that our job is to be objective and divorce ourselves from who we are, and to apply what we're taught in law school from day one is an objective set of laws that don't themselves reflect a value system. I believe very strongly it does reflect a value system, but we were really taught, again, in law school, and certainly over the course of time that I served as a state court judge, that our legal system and the laws that we have are intended to be seen as sort of a valueless, objective, externalized statements of what the rules are. So whether that's something that applies to a landlord-tenant relationship or applies to deep familial commitments like a marriage that's then going through a dissolution and there's children involved, that the job of the judge is to understand the law and apply the law to whatever the case is in front of her, and to do that in an emotionless and objective way, and to only make those decisions based on what comes in front of the judge from the lawyers or the parties who are in the courtroom. So in the tribal court system, the expectation was that I would understand as much as I could about the family in front of me, and to gather that information. And if I didn't have it in front of me in the courtroom, that there was an expectation that I would figure out some way to have that information, whether that was to ask the parties to tell me more, or whether I got that information on my own, which was encouraged in many communities. Those were things that in the state court system, I was not only dissuaded from, but really by the rules not allowed to have. So I was limited to making decisions based upon what the lawyers presented to me in the courtroom. And on the criminal side of things, when I sentenced someone to a prison term, for example, we never talked about what it would mean when that person returned to the community. And the vast majority of people in our criminal systems, whether they are being sentenced for very serious felonies or misdemeanor cases, they are going to come back. They're going to be released from jail or prison, and they're going to come back to the community. There was almost no discussion, with one exception that I'll get to in just a moment. There was almost no discussion of what it would mean to the community when those folks returned. What would reentry look like? Where would they live when they came back? How would they be employed? If they were not employable for one reason or another, how would they find support in the community? Those were questions that were really not even questions that I saw asked very often, if ever, on the state court side, because we don't really provide for that in our system of laws on the state court side of things, with the exception of therapeutic court approaches. And by that, I mean things like drug courts. I presided over the felony drug court in Whatcom County for several years. I've been involved in the development of therapeutic courts, not just drug courts, but also other kinds of therapeutic approaches to legal problems. And in those therapeutic approaches, the entire goal is to support that person address the reason that got them involved in the legal system in the first place. And whether this is the first time they've been involved in the legal system or the 10th time that they've been involved in the legal system, in a therapeutic approach, the judge is serving in a role much like what tribal court judges do all the time, and expected to work with a team of people to support that person so that they can rebuild their lives. And ultimately, once they've completed the program, to leave and not come back and be re-involved in the legal system. with the exception of that experience of presiding over a therapeutic drug court, I had very limited opportunities to really understand what brought people to my court system. You might think that I'm thinking about that just in terms of sort of families and children, and I've primarily talked about that. But in the tribal court system, I also did civil cases that involved businesses and often involved lawsuits involving multi-million-dollar contracts. And again, the approach was different to the approach that we have in our state court system. Even though we were talking about business models and businesses and disputes between businesses, the approach to resolution of those cases was completely different to the approach that we take on the state court side. So what that has taught me over time is that we are making choices constantly, whether that's the judges we elect to the bench or seek to have appointed to the bench, or the law that is reflected in the written common law developed by appellate courts, including our Supreme Court, or the law that is passed by the legislature. Those are things that are reflecting values. They are reflecting what we think is important. And so, you know, as I said, at the beginning of this, I never imagined being on any Supreme Court. And so when the Chief Justice Fairhurst announced her retirement and there was going to be an appointment to fill her position, I had several people ask if I would be interested or would be willing to consider applying for that position. And once again, it seemed almost absurd to me to even contemplate that I could be filling that tremendous void left on the court by Justice Fairhurst's retirement. But I did choose to apply. It took some significant convincing. And really what I was told by a number of people was, you know, Governor Inslee is going to appoint who he's going to appoint, but you need to give him an opportunity to consider appointing the first Native person to the bench. And that made a lot of sense to me. I was surprised and continue to be surprised that I'm in this position. I, as you know, had a contested campaign last year and was able to retain my position. So I'm glad to be able to continue serving the state of Washington in this position. And I'm hoping that over the course of my time on the Supreme Court, that I can bring some of the work that I've done in tribal courts and my thinking about what our state courts values are and what we're reflecting in the work that we do on the Supreme Court to the citizens of the state. I just want to give you one brief example of the way I think that I think that can play out. When I was presiding over drug court in Whatcom County, we had a young woman who I had known for a long time, who had been in my courtrooms in tribal courts as a juvenile, as a child in a child welfare case, as well as a juvenile on a juvenile offender calendar. I knew her pretty well. She turned 18. She had a pretty significant issue with drugs and alcohol that continued for several years, and eventually she arrived in my drug court in Whatcom County. So I knew a tremendous amount about her life. I knew a lot about her family, and I knew a lot about her community and culture because I had been welcomed by that community into learning about her culture and community when I worked for that tribe. So she asked for something very unusual after being in our drug court for about 6 months. In the first stages of drug court, people who are our clients come into drug court on a weekly basis. So the judge sees them every week. They see their case managers every week, sometimes more than once a week. They're doing random urinalysis, drug testing on a weekly basis. So they are very much, someone has eyes on them throughout their early months in drug court. And I had this young woman come into the court and ask me and the drug court team if she could leave for somewhere between 4 to 5 months and go into the traditional smokehouse. And I'm not going to describe that in much detail because I don't have permission from the community to do so. But when she asked that, I knew what she was talking about. And the case managers and others who were working with her didn't have a lot of information, but they understood that what she was asking for was to be away from case management and courtroom oversight and go into a traditional healing space for several months over a winter. This was something that had never been contemplated by our therapeutic court. It wasn't a request that had ever come in before, although we had certainly had tribal members from the same community in the court. And so she requested that she remain in drug court, but be gone for this period of time with some potential for a way to have some check-ins to make sure she was still there. And so we had a separate court hearing where she asked me for that permission. She brought people from the smokehouse to talk to the court about what they would be doing in terms of monitoring her and making sure that she was safe and remained sober during the time that she was involved in this traditional practice. I granted her that request. She immediately reported to her tribal community's smokehouse. We didn't see her for several months. And she came out a changed young woman. She continued to participate in our drug court for another year or so, working her way through our program, and graduated successfully from the program and continues to be in communication with some of our case managers and occasionally with me. I use that as an example, not to say that I did anything particularly special there, but it is, I think, a good example of how who you have as your judges in your communities matters to how you serve those communities. That I was told that request had never been made before, even though there had been clients who sought it, but they didn't think that they would really even be entertained by any judge to consider that. And this person felt that she could ask me for that. So I just will sort of leave you with that example. I think that having the most diverse Supreme Court in the country is a really powerful thing for the state of Washington. And I think what that means is that we have a group of 9 people on our Supreme Court who bring very, very different life experiences to the work that we do. We bring different views of the law to the work that we do. And as Justice Johnson has said many times when we have all been in significant disagreement, that his belief, he has served on the Washington State Supreme Court longer than any others of us on the bench right now. He's been on the court for over 30 years. He says regularly that we are at our best when we are in disagreement. And it's taken me a while to understand that, but I agree with that because what it means is that I learn from other people's perspectives and thoughts about the law. And I think that ultimately makes our decision-making better. So I'm happy to take some questions now. And I again, just want to thank you for giving me the opportunity and time to talk to you today.
I want to first thank you very much, very much. And it's intriguing. It makes me want to go read up some more on tribal law and the differences actually between the Pacific Northwest and the Southwest. So I'm going to actually turn it over to Robin and Susan, who can show up if they want, or they can stay behind their name. But they've been watching the questions, and what do we have?
The first question I have is, what is the benefit of state codification of ICWA? This is from Meredith.
Well, I'll just, so that we're all on the same page here. The ICWA refers to the Indian Child Welfare Act. And there are, Meredith, I may have to ask you a clarifying question, but there is a federal Indian Child Welfare Act. And the purpose of that act is to prevent the disruption to Native families that our child welfare systems have had on Native families over many decades. And the state of Washington also has its own Indian Child Welfare Act called the Washington Indian Child Welfare Act, and that's the state codification. It's not the same as the Indian Child Welfare Act. It has different provisions, and it's also more detailed in some areas where the Indian Child Welfare Act on the federal side is not as detailed. And I think that it reflects a commitment on the part of the state to ensure that Indian families are well served by the child welfare system if they get into the child welfare system, and to ensure that judges have clarity about what the law is in the state of Washington.
All right. Okay, the second question is from Anne. She wants to know if there's any way to translate the traditional healing that you described into non-native culture, and is there any way for judges to encourage a practice like this that might have a greater effect on troubled youth rather than going to jail or being under constant management and having to submit to your analysis and all of those things?
Well, I think what's really important is that whatever we're doing in our court system, particularly when we're talking about young people, whether they're under the age of 18 or they're still, young folks in their early 20s, is that we are thinking about alternative ways besides just sort of management once someone gets in trouble. I think the biggest thing that I think has the potential to prevent that is earlier interventions, and sometimes by that I mean much earlier, that don't have anything to do with the legal system. The best thing we can do for young people is to have them never get involved in the legal system in the first place. And I don't say that lightly, but I do say that with the backing and support of many decades of data that show that once young people get involved in the legal system, it's very hard for them to get out of the legal system, and that they're much more benefited by diversion programs and other things that take them out of it. In terms of the healing practices that I talked about, I think the things that I make reference to are sort of an example to ask you to think about. What are the things in your own culture and community that might be supportive of the kids that come from those communities that are getting involved in the system? I don't think that traditional tribal practices translate necessarily. And I also think that many tribes, and I'll just speak for myself, from my own tribe, my tribe is not one that would ever share those things, and I'm not permitted to share the kinds of things that I've seen in my community used as healing approaches outside of that community. It's considered to be very private, and there's good reason for that. But I think what it reflects is that all of our cultures have strengths and things that we can use to support our children and families. And I think we don't necessarily think about that. We think that the people that are getting into trouble are there for a reason, and the legal system will deal with that. And I don't think we're equipped to. I was very lucky that I got a master's in social work, because it has helped me tremendously as a judge. But most people don't. Most people who become judges have to sort of figure those things out on the fly. And I think that's very difficult. We're asking a lot of our legal system and our judges.
The next question is from Daryl, who says, what is victim rights in tribal systems?
Well, it's hard for me to speak generally in terms of tribal systems, but what I have seen in the work that I've done in the tribal communities I've worked with is that there is really never a solution to a criminal problem or a resolution to a criminal case that does not involve the victim, and most often the victim's families as well. They are always consulted before resolution is presented to a judge. So if there's going to be a sentence that's imposed by a court, it's the expectation of the tribe that the tribal judge understands that the victim's family has been consulted and that they've been a part of coming to that resolution. They don't necessarily always agree with it, but it's absolutely a critical foundation to the approach to criminal cases to ensure that victims feel like their voices have been heard. There's also something that many tribes use called peacemaking, and I've been involved in developing peacemaking approaches that happen outside of the courtroom that are done through a traditional process called a peacemaking circle. And you can look that up. That's actually been something, that's one practice that's actually made the transition into state systems. And there's actually a very good documentary that talks about that, where the person who committed the crime or committed the harm to the victim and the victim's families all are in a room together, usually with leaders in the tribal community, sometimes with the judge. I was involved in one approach where the judge was a part of those circles, where a facilitated conversation occurs, where the victims and the victim's family are able to talk about the impact of the crime. And the person who committed the crime is also able to talk about what was going on for them and what happened. And the goal of that is to come again to some kind of agreed upon resolution that is going to resolve the case in some way. And that typically happened in a way without there being like a court order or even a conviction, although sometimes there are times where there's a mix of both of those things happening at once. But it's very unusual in my experience that there'd be a resolution to a criminal case where victims were not involved.
Another question, kind of finding out if people are following in your footsteps. Are there many young tribal members going to law school? And if not, how would you encourage them to become interested in law and maybe becoming a judge someday?
Yeah, that's a great question. There are lots of young Native people going to law school. It's really an important part of my job, I think, in my work to support those folks, and I try to do that in many different roles, as do other Native lawyers and judges who are out there. We really are a small community of lawyers, and we mostly try to get to know each other and support young people who are coming up. It in my view is astounding that I could be the first Native judge on the Washington State Supreme Court, and it would be meaningless, I think, to whatever amount of time I serve in this position if I don't ensure that people follow me, and that I'm not the first and last, but I'm the first of many. So, I think that there is a very active group of educators, judges, lawyers who are Native, who support young Native students coming into law school, making sure they graduate and move on to careers that are meaningful for them.
There are a few questions that want to know more about why there aren't more therapeutic sentencing, or how we could take this approach that you've talked about and integrate it into the court system. And I'm thinking that has something to do with a question that I've come up with, which is that there is some tendencies to offer youth that are committed to have dispute resolution utilized.
Mhm.
And I think it's in Whatcom County that also is using pretrial diversion tactics. And that seems to be, the dispute resolution process seems to be very much like the peacemaking approaches. And so I'm just wondering if that is something that you would think that we should try to advocate, that the legislature would have those strategies be put into the toolbox for courts to use to try to both have that conversation with the victim and the perpetrator, and key figures in the community, and support individuals for the victim and the perpetrator meeting with a skilled facilitator who would try to find out how each could try to have some resolution that would be satisfying to both help the perpetrator not do that offense again, but also to have some support for the victim so that the victim feels like he or she is safe, and that, you know, a just resolution has been done. What are your
Yeah, it's a great question, and it's a complicated one. I will first say that there are many therapeutic court approaches in Washington and beyond. There is really an explosion of interest in that kind of an approach to all kinds of things, including things that I think many would have thought wouldn't be feasible. And I'll give you an example. There are well-studied and well-supported batterers intervention programs that work with people who are perpetrators of domestic violence in a therapeutic setting, like a drug court setting, where they are required to go to a batterers intervention program, but also are required to engage in case management and coming in front of a judge on a weekly basis, very much like a drug court kind of approach. That's been very well studied over the long term to see how it's successful in reducing continued domestic violence, whether it's in that particular relationship or in other relationships that might follow, if the person that's in front of the court moves on to different relationships. That's been proven to be successful in reducing domestic violence. And that's an area where I will speak honestly and say that when I first learned about that, I was very skeptical about that being about a therapeutic approach being suitable for domestic violence, particularly people who'd had repeat domestic violence offenses. And I was happy to learn that I was wrong about my skepticism with respect to that. I think that many people view that as a best practice now. But the problem with those kinds of approaches is that they are more expensive. They require case management. So that means that you have to have people who are full-time staff members somewhere, whether that's working for the court system or working for a different group that provides case management. It requires that there's therapists who are skilled enough to do whatever that work is, and that they're interested and able to do it. And it also requires time on the part of the court, and it's very that approach is very time intensive for a judge. I think there's certainly in the drug court area a lot of data that shows that money is saved in the long term in terms of incarcerating people over and over again for repeat offenses. But it's still an upfront cost, and so a lot of local communities really struggle to make that shift. In terms of the second part of your question, and approaches to sort of restorative practices, there is tremendous interest in that area. I'm a little bit more tentative about that, because I think if you want to have a restorative approach in your local court system, you have to have judicial leadership involved in that. You have to have someone who's interested in learning how to do that, open to learning how to do it, because it is a set of skills that we are not taught in law school. And dispute resolution centers can be tremendously useful in that regard. And you're absolutely right. Whatcom County's dispute resolution center is at the forefront of many of those kinds of attempts to use dispute resolution practices that don't involve the court at all, or in some way working with the court to reduce the use of the court to resolve problems. But again, this is one of those things where there has to be a community commitment, because it takes leadership on the part of the judges. It takes other leadership in the community to make sure that those things are there and available and consistent over the long term for people who are coming into the court, whether they're coming in as victims of a crime or perpetrators of a crime.
This is sort of switching gears, but it's also very pertinent to the League's mission, which is education. Pam asked, the public votes on judges, but most don't have a clue about the people they are voting for. How would you suggest we can better educate the public regarding the judges they are electing?
Yeah, that's a great question. And it is hard, I think, as a voter to know much about judges. Judges are very limited in what they can say when they are running for office. I think the League serves a tremendous role with respect to that. And I was involved in many panels that the League had, both as a Superior Court judge and when I was running as to retain the position I'm in now, that really served an educational purpose. What do the courts do? What is this? Who is these people? And I think that's really all you can do. You can sort of put the information out there and hope that people access it. But many judges, are running for those positions unopposed. And so, if you don't really engage yourself in understanding who they are, you really don't know who you're voting for. And some of the best ways to do that are the things that, in addition to what I just described, are things that are really available to anyone. And that is to walk into a courtroom and watch someone work. Courtrooms are, the courtroom I presided in was not my courtroom. It was the public's courtroom. We have a very strong open courts requirement and expectation in this state. So go and watch the judges. Go sit and see what's happening in your courtrooms, and you will see tremendous innovation going on from the municipal courts up to the superior courts and the appellate courts. I rarely saw that. The most frequent thing I saw were young people who were required by a class to come in and watch a court, and they would pick mine for one reason or another. But they were very, reluctant to be there because it's an intimidating place. And I think it's really our job as a legal system to be sure that people understand that we're there to serve the citizens, not the other way around.
There is a question. Are you giving presentations to the National ABA to help lawyers and judges consider all the invaluable insights you have gained?
Well, I'm actually doing a presentation to some lawyers it's a panel from the American Bar Association on Friday. That's the first time I've actually done that. So it's so funny that I would get that question today. I do a lot of public speaking and a lot of educating, but I also have my regular work to do, and so it's a balance. I don't think I'm unique in my perspectives that I bring to this approach, and going back to this sort of ties back for me to the prior question. I really encourage you to get to know who the judges are that are serving your local communities. You have some amazing judges in Kitsap County, and that's with some real innovative work going on. And so, I think that I'm lucky to have the public voice that I have, and I'm grateful to be able to share some of those insights. But the work that judges are doing is really quite remarkable, whether that's in the tribal courts or in the state courts. So I am grateful to have been invited to speak today, and I hope you'll invite some of your local judges as well to talk about the work they're doing.
Maurie, you're on your
Almost did it. Almost had a
Well,
perfect record here.
right.
We are just about right on the 1:30 mark. So we could end now, or if we have more questions, if Justice is willing to stick around, we could. But if there are no additional questions, then I just want to thank you so very, very much for accepting our invitation. And we do hope to see you again. Maybe we'll come and watch you work.
Thank you. And I will just note, I saw that Judge Rothrock put in the chat, but I don't know that everybody can see that. You can watch the Supreme Court's oral arguments on TVW. We live stream them. In fact, we have arguments tomorrow. Today's Wednesday, tomorrow at 9 o'clock that will go. I think we have 2 cases in the morning. So they are live streaming on Tuesdays and Thursdays. It's not every Tuesday and Thursday, but you can look up what the docket is if you go to the Washington State Supreme Court website and see if there's any cases that are interesting to you. And those are also archived on TVW, so you can go and look at cases that we have heard and see how the court works as well. So thanks again. I appreciate your time.
We appreciate yours. There are additional questions in the chat, but we don't have the time for them. So I thank everybody for their questions and apologize that I didn't get them all asked.
That's okay.
Yes.
Next
We'll
time.
have to do it again. Yes. Thank you.
All right.
And thank you to everybody. Bye-bye.
Thank you very much.